Good afternoon. I hope this finds everybody safe and healthy at this very difficult time. My name is Erwin Chemerinsky. I'm the Dean of the Law School at University of California, Berkeley School of Law. And it's a tremendous honor and privilege for me to be part of this panel with three of the most distinguished state attorney generals in the country. The title of the panel, and I have to admit, I did not come up with it, but I love the title, is Reigning Supreme: How Democratic AGs Are Fighting and Winning in the United States Supreme Court. I'm going to do a quick introduction of the three attorney generals who are here. I apologize to them in advance that my introductions don't begin to do justice to their biographies, but I would try to do that. That's how we'd spend the hour. So quick introductions of the three of them. I'm going to do this alphabetically, starting with Attorney General Xavier Becerra, who's the 33rd Attorney General of the state of California. He's the first Latino to hold that office. He's a former member of the United States House of Representatives. He served 12 terms in Congress. Let me next introduce Attorney General Letitia James, who's the 67th Attorney General for the state of New York and is the first woman to be elected to the position. She served on the New York City Council for over a decade and was also New York City's public advocate. And finally, I want to introduce Attorney General Phil Weiser. He's the 39th Attorney General of the state of Colorado. Prior to running office, he was a law professor. He was the Hatfield Professor of Law, and he was Dean of the University of Colorado Law School, which is where we first met. And you made a good choice leaving being a dean before all of this happened.
Erwin, your job is harder than mine. I can tell you.
I don't know. They're all very difficult at this point in time. But as I said, it's a huge pleasure to be with these three tremendously distinguished individuals. I was asked to offer a few observations about where the court is now and where it's likely to go in the foreseeable future, given what happened last term, and we're going to also talk about what's on the docket for this term. My first observation might be phrased as a question. Why was last term different from all other terms? Well, there are many reasons. The Supreme Court decided fewer cases. The Supreme Court decided only 53 cases with signed opinions after briefing and oral argument. That is the fewest number since 1862. The court canceled its oral argument calendars in March and April. The last time the Supreme Court did that for a month was in October 1919 because of the Spanish flu. The Supreme Court rescheduled 10 of the canceled cases for argument in May, and it had telephonic oral arguments. Attorney General Weiser argued one of those cases by telephone, and I want to ask him about what that experience was like. The Supreme Court did live audio broadcasts of those oral arguments. This is the first time the Supreme Court has ever done live broadcasts of any oral arguments. The court has been so resistant to audio or visual broadcasts, but it also meant that we, all of us, could listen in. And Attorney General Weiser, I listened to your argument. You were terrific. And it was wonderful for us to be able to participate in that way. I hope even when they go back into their majestic courtroom, they'll continue the tradition of live broadcasts of the arguments. My second observation about the court is it's truly the John Roberts court. John Roberts was in the majority in 97% of all of the decisions last term. He dissented only twice the entire term. As you know, when the chief is in the majority, the chief gets to assign who writes the majority opinion. The chief assigned to himself writing some most important majority opinions of the term. For example, we're going to talk some about the case involving DACA, the deferred action of childhood arrivals, and Chief Justice Roberts wrote the majority opinion there. When Justice Kennedy left the bench 2 years ago, many remarked that it was going to make John Roberts the median justice on the court ideologically, the swing justice. It's hard to remember an instance where it was the chief who was the swing justice. We have this now, and so long as these are the 9 justices on the bench. My third observation is it's a term that defies easy ideological characterization. The term ended on Thursday, July 9th. That's remarkable in itself. It's been decades since the Supreme Court went so far into July to finish the term. Obviously, that's because they had oral arguments in May. When the term finished on July 9th, many reporters who cover the Supreme Court talked about the surprising liberal decisions. And to be sure, we'll discuss some of them. Many were surprised by the DACA ruling that we'll talk about. Many were surprised by the Supreme Court's decision that said it violates Title VII for the employment discrimination on the basis of race, on the basis of sexual orientation or gender identity. Title VII, of course, prohibits discrimination based on race, sex, and religion. And the court said it also now forbids employment discrimination against gay, lesbian, or transgender individuals. The court ruled 5-4 that a Louisiana law that regulated abortion was unconstitutional. The Louisiana law said that in order for a doctor to perform an abortion, the doctor had to have admitting privilege to the hospital in 30 miles. There was an important brief filed by attorney generals of states urging the court to strike down the Louisiana law, as it did, John Roberts being the 5th vote for the majority in that direction. Yet, it would be a mistake to see the term overall as a liberal one. I find a statistic here to be particularly revealing. There were 14 5-4 decisions out of the 53 cases. In 10 of the 14, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. In 2 of the 14, the majority was Roberts, Ginsburg, Breyer, Sotomayor, and Kagan. And then there were 2 other 5-4 decisions with a different composition of the just and the majority in dissent. So when you look at that statistic, in the 14 5-4 decisions, the 5 conservatives in the majority in 10 of them shows it really would be a mistake to see this as a liberal court by any means. And there were notable conservative rulings. I would point especially to the decisions with regard to the religion clauses. In one case, Espinoza v. Montana Department of Revenue, the Supreme Court said, whenever the government provides aid to private secular institutions, it is constitutionally required to give that aid to religious institutions, unless doing so would violate the Establishment Clause. Or another case, with Our Lady of Guadalupe School versus Morrissey Baru, where the Supreme Court said that a religious school cannot be held liable for employment discrimination with regard to the choices it makes as to who will be its teachers. So even as to lay teachers teaching secular subjects, a religious school can't be sued for employment discrimination based on race or sex or religion, sexual orientation, disability, or age. I could point to other areas as well where the conservative justices were clearly controlling the direction of the court. As we look ahead to the future, it's important to focus on the age of the justices. Of the conservative justices, Clarence Thomas is the oldest, he's 72. Samuel Alito is 70. John Roberts is 65. Brett Kavanaugh is 54. Neil Gorsuch is 52. It's possible to imagine these justices being together another decade or more. Of the liberal justices, you have Ruth Bader Ginsburg, who's 87, Stephen Breyer, who's 82, and then you have Sonia Sotomayor, who's 64, and Elena Kagan, who's 60. So you see a real difference in terms of the age of the justices based on ideology, which means that the next election could make such a difference in terms of the future composition of the Supreme Court. Well, that's my quick overview of last term, but now I want to turn to the Attorney Generals for their experience and their perspective with regard to the term. And Attorney General Weiser, I'd like to begin with you, and I'd like to talk about the case that you were involved in. It came down under the title of Chiafalo versus Washington, but the case you argued, Baca, came from Colorado. Do you want to talk a little bit just about the case? And then I want to ask you about your experience in arguing by telephone.
Sure thing, Dean. And I have to say, it was a dream experience to argue for the Supreme Court. I had had the chance to clerk there during a fairly historic term when Romer versus Evans was decided, which is another important case about equality. This term, I was arguing for democracy, because in our case, the issue is, would the right of the voters to have their votes be counted be honored? Or could a elector go rogue and in effect dishonor the voters and decide to do something based on his or her own preferences? That was an issue that had never been resolved. There is this theoretical ideal out there. If you look at Alexander Hamilton's Federalist paper, you can see some support for it, that electors get to be free agents. In Colorado, we've long had the view, no, they're bound agents. They're proxy voters, if you will, on behalf of the people of Colorado. We lost in the 10th Circuit Court of Appeals. There was a contrary ruling in the Washington Supreme Court. Both of us sought certiorari. The court took both cases for argument, and we had a chance to argue, as you noted, during the pandemic by telephone. It was a different format too, and I'm happy to chat a little about that if you've got specific questions or just general ones.
What was the experience arguing by phone? I've argued in the courtroom. I argued a case last November and lost by the close margin of 9-0. You won 9-0. But what was it like to argue by telephone?
It was a little surreal because the justices were disembodied voices. I was in my conference room looking out over Denver and was able to have my family there and a little bit more flexibility on the beverage choice. In the actual Supreme Court, you can only have water. I could have iced tea because this is my conference room. And I was able to have a much more intimate experience because each justice got their own time to ask questions. And this is something, Erwin, you made the point, will there be changes because of this format change? For example, the live audio broadcasting, I'm with you, I hope that that stays. Another question is, will justices get some version of their own time to ask questions? And part of what happened was justices like Clarence Thomas, who rarely ask questions in the free-for-all format, did ask questions, including the very thoughtful question of my opposing counsel, because their theory was that the state had very limited power. So he said, well, what if an elector wanted to vote for Frodo Baggins for president? Could they do that? And I thought that got to the weakness of their argument that the state had no oversight. Our argument was the state needed to have plenary power oversight. So I found the format actually more engaging, with each justice being able to dig a little deeper into each of our arguments, and every justice got a chance to speak.
Did you like the format better because it was more orderly? On the other hand, what about the loss of depth of questioning? Because often when there's the usual questioning, a justice will ask a question and then another justice will ask a follow-up to that. Whereas with this format, if the first justice asked a question, the follow-up might not come until the fifth justice was asking questions.
That is correct. It is a little less pile-on-ish as it might otherwise be. But here's the offsetting benefit. It was also less justices asking questions to make points to other justices. One of the features of the modern Supreme Court is that oral arguments are both for purposes of the advocate to develop his or her case, but also for the justices to make points vis-a-vis other justices. And sometimes that second purpose can actually crowd out the first. So I appreciated that it was a conversation between me and a justice and not necessarily between the justices.
How did it feel to not be able to get the visual cues that you usually get at oral argument?
That was definitely a hard part.
Oh, yeah. No, even as simple as, I know when somebody's about to ask me a question because they're leaning forward and they're giving those cues, whereas over the phone, you don't have that.
The good news was I knew who was going to ask the question because they went in order of seniority. So there was no mystery there. I had also listened to the arguments preceding. I was the last one to argue. Literally, I was the last voice that the court had before it went out of session. So I was equipped in that way. What was difficult, as you note, is you didn't get the reaction of the justices. Justice Gorsuch was able to, by his verbal cues, communicate that he didn't quite get the answer he wanted, but you could have gotten those cues just by looking at people if you had that benefit. So that was a major downside risk. On the other side, it also didn't have the same necessary intimidation factor. I do think that it is an intimidating environment. I've been there as a clerk for, I've worked on Supreme Court cases, but this was my first Supreme Court argument. And in one sense, I got to do it with a home court advantage.
Let's talk a little bit about the substance of the case. Justice Kagan wrote the opinion for the court, and she really stressed that the Constitution doesn't speak to this, and therefore it should be left to the states. Justice Thomas wrote separately and put that in terms of the 10th Amendment. Was that similar to what you were advancing in your argument in briefs?
Kagan's opinion was very similar and compatible to our argument. We invoked the 10th Amendment as an interpretive principle, a little bit like Gregory versus Ashcroft, that if something is a close call, then leave the states with authority. we did not say that the 10th Amendment was a source or basis for state authority, which is where Thomas wanted to go. There was another principle that came up in oral arguments, which I think also informed the opinion, didn't come out quite as clearly, which Justice Kavanaugh called the chaos principle, which is when you've got a close case, decide it in a way that doesn't create chaos. And the concern here was if electors can go rogue and do whatever they want, then electors could be bribed. And the spectacle of a bribed elector or an elector subject to extortion is something that I frankly don't want to ever see happen, because in a close presidential election, think the 2000 election, all you've got to do is bribe a certain number of electors to switch their vote. And either they do so and no one's found out about it and you can change the outcome, or the electors get found out and Congress can only disqualify but not replace electors. So that could have the effect of throwing the election to the House of Representatives, also undermining our presidential election system. So the amount of mischief or chaos that could have happened had we lost was substantial. And it was very important to have an orderly election system. And just to bring it to literally today, I'm filing with other state AGs a case against the Postal Service for their undermining and slowing down of the mails as an interference with the state authority to manage their elections. That was the same issue in this case, the Baca case, that states have the authority under the Constitution to manage elections. That's an argument we're now making again in this Postal Service litigation.
And of course, the case that you won could in the end decide the November 2020 presidential election. If it is very close, if there were faithless electors, they could shift the election one way or the other. And of course, now we know that a state, if it chooses, can prevent faithless electors either by replacing them or punishing them, as the state of Washington did. Let me ask you one other question. This was, you said, your first argument in the court. What took you most by surprise? If you were speaking to other state attorney generals who are about to have their first argument, is there any advice you'd give them from your experience?
So it's something I knew intellectually, Erwin, and it was really confirmed here, which is you've got to be super well prepared, because the justices are not only thinking about the case in front of them, but the next case or the case after that. And so one of the most difficult lines of questions, something that Xavier, my colleague and good friend from California, has had to litigate there, is the presidential qualifications clause. In California, it's whether or not you can condition someone's access to the ballot by whether they've released their tax returns. That issue, the presidential qualifications clause, was not immediately relevant in this case, but the court was thinking about these issues. And so both with Justice Kagan and with Justice Gorsuch, I had quite a back and forth on this issue, which was merely a footnote in the opinion. There were also other alleys that I was prepared to go down, but the court didn't get to, but you had to be prepared to discuss all those issues. So I think my advice to anyone arguing the Supreme Court, which again, I knew intellectually, but I got to experience, is you've got to be really well prepared, because you're going to get asked questions, not just in the case in front of you, but in adjacent cases as well.
Thank you. I want to come back and talk some more, but I also want to bring in Attorney General Becerra and Attorney General James in the conversation. And the case I want to focus on in talking to both of you is the DACA case, Department of Homeland Security versus University of California. I'm sure that everyone is familiar with it. President Obama issued an executive order, the Deferred Action for Childhood Arrivals. It applies to individuals who are brought to the United States under age of 15, who are in school or successfully graduated, in the military, honorably discharged. They can qualify for DACA status so long as they don't have a felony or serious misdemeanor conviction. It gives what immigration law calls deferred deportation status for a 2-year period, which also meant that they could get work permits and other benefits. About 800,000 people, it's estimated, have benefited from the DACA program, many on my campus, some in my law school. President Trump, as part of his restrictive immigration policies, ordered the Department of Homeland Security to rescind DACA. And I'd be really interested in turning the two attorney generals. What was the role of each of your offices in bringing the challenges to DACA? I know that both of your offices were so involved in this. Attorney General Becerra, maybe if I could start with you. You're on mute. Attorney General Becerra, you're still on mute.
How about
There you
now?
go.
Yeah.
Okay.
Now we can
Well, I
hear
was just
you.
saying thanks, Dean Chemerinsky and Daga, and certainly my two colleagues, AG James and Weiser, for being able to participate with them. Look, but we new is that in California, 1 in every 4 dreamers lives here. We're the most impacted of all the states because we're just so big. And as we went through this process, we knew that we had to show that the administration was essentially going about doing its business in the wrong way, not following the rule of law. And so when we decided to file, it was based on the fact that this administration, and it's been proven over and over, is very sloppy and very impatient in trying to change the law. And the process of trying to change the law, they break the law. And so when we went to court, while most people didn't expect that we could defeat a president in trying to undo an executive order, we believe there was a very strong chance that given the way they tried to do this, the process they used, that we had a chance to prove that you still have to follow the law even if you're in the White House. And I suspect that once history books write about this decision, they'll talk more about how it was an indictment about the way Donald Trump and his administration did business than it was about the substance and the legal ability for presidents to issue executive orders.
So I represent New York, which is an immigrant-rich state. And the Roberts Court, as you know, has sought to basically impose some sense of stability on the courts. And it really comes down to the credibility of the United States Supreme Court. And so I respect Roberts for this past term and his ability to sway the court in particular ways. And I don't want to basically describe this court as either a conservative majority or him leaning towards the towards the left. He's really the middleman, if you will. And he recognizes that the stakes were high. He relied significantly upon this reliance theory and what was at stake for these dreamers, and the economic impact to our respective states. And so clearly this administration, unfortunately, has this animus towards immigrants, and they're at it again, as you know, by raising fees, as requiring dreamers, they're limiting their ability to work from 2 years to 1 year. And in some cases, not in some cases, in all cases, not accepting new applications. It's as a result of that attorney generals all across this nation, but in particular, Attorney General Becerra and I stand up for the rights of these individuals who came to this country through no fault of their own, who are only seeking opportunity and freedom. Let me also say, I want to congratulate all of the labor leaders who are on the call today, because as you know, along with my colleagues, we won a significant case in the district court, the Southern District Court of New York, where this administration sought to limit the standard for joint employers, and by basically challenging them on wage and hourly rates. And I'm glad that we were able to protect the labor rights of countless number of employees throughout this nation.
I want to ask you a question, if you'll be honest. Were you surprised by the court's ruling in the DACA case?
Is that to me?
Sure, and then I'll ask
Okay.
the same question.
Was I surprised? To a certain extent, I was surprised. But I recognize that if you look at the history of Judge Roberts, he is an institutionalist who cares a lot about the direction of the courts. And at a time when there is so much dysfunction in the executive, and because you cannot rely upon Congress, it's important that the courts provide some stability. And that is what Justice Roberts is attempting to do. I know that a number of conservatives are disappointed in his decision with regards to DACA, with regards to ACA, with regards to the census. But the reality is that right now he is probably the most stabilizing force in government at this point in time. The courts are the most stabilizing force in government. And the facts and precedent are clear. And he, again, is opposed to overturning precedent. And for those reasons, although I was pleasantly surprised, I recognize the fact that his decisions are narrow and they're pragmatic, but they still leave the door open for challenging DACA, for challenging the census and the ACA.
And Dean, I'll just add that you probably were among those who were saying this is a Hail Mary pass when we first were filing this case back in 2017. But listen, I'm going to shock you here. I'm going to say something that may surprise a lot of folks. The Supreme Court is as political an animal as any other branch of the U.S. government. Surprise, surprise, there's gambling going on in this institution, Humphrey Bogart would say, right, in Casablanca. The truth is this, if you look at the facts in this case, what were you going to do with 700,000 to 800,000 young people who relied on the government's commitments to come forward in a way that put them into real harm? They did it to their detriment, right? They relied on the federal government to their detriment. And here you have an administration which was, as I said before, sloppy and impatient, and didn't try to do this by dotting its I's and crossing its T's. It gave this court, at least Chief Justice Roberts, a chance to side with those who thought that this was wrong and come down with this decision. So while I was certainly, I certainly knew this was going to be a harder touchdown than others, I felt confident that moving forward, and after watching the argument, I felt confident that there was still a chance that people would realize that you can't disrupt the way we do business in this democracy this way. And you've got grounds on which to base a decision to say, no, you can't do that.
There wasn't sound, oh, sorry, there just wasn't any reasoning behind their decision. And it placed undue burden on these individuals, and it created uncertainty, which was totally in opposition to which was the basis for DACA. And so I apologize, Attorney General Weiser.
No, it's great. So with the football metaphor, I'm so glad to have Attorney General Becerra and Attorney General James as our quarterbacks, because we did have a great team to bring this case forward. And to square what they both said, yes, the Supreme Court has to act and think politically to protect its authority. And getting to what General James said, if John Roberts didn't think about the institution and was willing to decide something, say, on an ideological basis, that would compromise their institutional credibility. And I do believe that with respect to the ACA case, the census case, and the DACA case, Chief Justice Roberts is playing a longer game, thinking about the court's institutional credibility. And that has acted as a constraint in service of the rule of law, because what's being protected in those three cases is the concept that we don't make up rules to serve ideological objectives, or to put it in one way, we don't play naked politics. And that's why the ACA case coming up is such a test of the rule of law, because the legal theory, to use a legal phrase, is a wackadoodle theory. It doesn't make any sense. To rule on that ground would be doing violence to the rule of law. And in the census case and in the DACA case, that's part of what was at stake.
And I think Justice Roberts realizes at a time of rancor and polarization and the great divide in this country, that he sought to maintain precedent. And so, again, if you look at the polls, and if you look at polls based on the credibility and the respectability of the courts, Congress, and the courts of Congress, as well as the executive, you will see that the Congress is in the teens, the executive is in the 20s or 30s, and the Supreme Court is in the 50s. And I think that is what Justice Roberts is concerned about, its legitimacy.
Let me take what Attorney General Weiser said and build on it. All of you have been very involved in challenging the immigration policies of the Trump administration. Maybe I can turn especially to you, Attorney General Becerra, because this is something that your office has consistently done. Could you describe what your approach has been and why this has been such a central focus for the kinds of lawsuits that you've brought?
So, Dean, for me, these cases are more than just legal challenges. They're very personal as the son of immigrants. And again, looking at the long game, and I think the three of us are saying the Supreme Court, at least some of the justices, look at the long game, and certainly the guy whose court it's named after, John Roberts, I think, looks at the long game. You can figure out a way to get to a result. These 9 justices are all smart. They got some of the brightest clerks working for them, you can write a decision that says almost anything. And for us in California, there's no backsliding. We can't afford to do that, just as we can't backslide on the environment. And you can see why, given all these wildfires and the haze in the air. Even if you live 200 miles from a wildfire, we cannot roll back these protections for people. And so whether it was 1 in 4 children in Central California growing up with asthma because of the quality of the air in the Central Basin, or whether it's 1 in 4 of the DACA dreamers living in California, for us, it's not we don't do it because it's fun. We don't do it because it's easy. We take Donald Trump to court because it's necessary. And all these immigration cases, it's necessary because California didn't become the economic engine for the country, now the 5th largest economy in the world, by dissing its immigrants who are very hardworking. We tell people, you work hard, play by the rules. There's a place here in California for you. And we've proven that works. And that's one of the reasons why not only is it personable, but it's also a winning strategy taking on the Trump administration on immigration.
Maybe
this administration has engaged in countless number of policies that basically harm individuals, direct and quantifiable harm to our states and to the people we elect to we're elected to represent, not only in the area of immigration, which for the most part has been the sole prerogative of the federal government, but in the area of EPA. Attorney General Becerra was just talking about the fires that are happening in California and Oregon. The reality is that my office has filed a significant number of challenges to this administration because I know right in my own community, a significant number of children, and particularly children of color, are suffering from bronchial and asthma problems. And so it's not like we're happy to sue this administration. We're doing it because we have to protect the interests of our constituents and protect the interests of our state because of the direct and quantifiable harms.
Attorney General James, I'd like to focus on a particular case that your office brought, and the case is named Department of Commerce versus New York, and it involved the choice of the Department of Commerce to add a question about citizenship to the 2020 census. How did your office come to bring this case, and what was the experience like in litigating it?
So it's basic for me. It's about defending the Constitution, and it's about defending all persons, and it's about sending the message that immigrants matter too, and that counting all persons is critical to a full functioning democracy. And so it's really critically important that our decisions reflect upon the Constitution and the rule of law, and that this administration not politicize the census. And we know that what he was attempting to do was basically transfer power from urban centers like New York and California to southern states. And we recognize that this was nothing more than a political decision, and that putting the citizenship question on the census had nothing, there was no basis for it, there was no rationale for it, and therefore it was in violation of the Administrative Procedure Act.
And you won 5-4, just is the same split as in the docket.
Same split.
Same and same underlying reasoning. In both cases, Chief Justice Roberts said that the Administrative Procedures Act in prohibiting arbitrary increased actions requires an articulated legitimate reason. And in your case, go ahead, please. Justice
Roberts appears to be a stickler for the rules. And so by not following the rules consistent with the Administrative Procedure Act, and they have consistently not followed the rules, we have used the Administrative Procedure Act on a number of cases. We fought back their dangerous policies. They're policies which unfortunately have racial animus, and we've been successful. And it's unfortunate, and I'm glad that the courts have not decided to look at the basis or the reason for their decisions, because they're pretty much offensive, but on the face of it, it appears to be based on racial animus. But nonetheless, I am so glad that Justice Roberts decided to join with the ladies on the court and do the right thing.
Attorney General Weiser, if I come to you, are there special considerations for you in deciding whether to sue the United States government?
It's something I do lightly, and I think this is what General James said too. There's nothing I'd like more than not have to sue the federal government so that they follow the law. It is a grave concern to all citizens that our federal government is showing a disregard for the law, the rule of law, and following the rules. And I have to try really hard every time something happens to say, is this a violation of the rule of law? And does this hurt Colorado? Because there are some decisions the federal government makes that I conclude, okay, there's not a legal problem here. It might be a policy I disagree with, but there's not a legal problem. But I think what General James said is right on with respect to the census. It was done in disregard for the purpose that the law was passed. So I took an action recently against the federal government, getting back to environmental protection, whereas the Clean Water Act, where the federal government undermined water quality protection to a degree that we've never seen in the 50 some years of that statute. And that's something that, again, leaves me really concerned because we in Colorado depend on water. It's the lifeblood of our state. If we gut the water quality protection, it's going to have all sorts of really negative side effects. So that was something where I looked at it and concluded that they did violate the law and act, again, not with the purpose of the law in mind. And this is something which hasn't always been the case. We've had administrations before that have interpreted, let's say, reasonable differences one way or the other. But I think in this administration, we've seen, whether it's immigration or I'm talking now about water quality protection, a level of disdain with the purpose of these statutes. And that's not okay. The Department of Justice, back to a topic that I know is very close to AG Becerra's heart, it has a job to do to defend and enforce the Affordable Care Act, to take care that the laws are faithfully executed. They're not doing that job. It's incumbent on state AGs to do that job to protect the people of our states.
I want to come back to the Affordable Care Act in just a second, but let me ask a harder question. Imagine that there are some AGs here who are Democratic AGs, but are maybe in red states or purple states. To what extent do the political considerations influence whether to sue the United States government? I mean, the reality is California and New York are blue states, and suing Donald Trump certainly isn't going to hurt any elected official in the state of California, state of New York. What would you say to the Attorney General who's not in such a blue state? Should the political nature of it affect whether to sue the United States government? And I guess I ask you because Colorado is more purple than New York or California.
I'd say you never do it lightly. It would certainly be our preference not to do it. In the case I just mentioned, the Clean Water Act case, we filed comments providing a roadmap for what we thought was a lawful way, following Supreme Court precedent, to interpret this law, arguing for guidance that was adopted under the George W. Bush administration. And the administration decided not to follow the roadmap that was best for Colorado or consistent with the rule of law. They decided to gut this important federal law. And it's my job to defend the rule of law and defend the people of Colorado. And so I'd say, Erwin, there's two questions. What's best for the people of your state and what's best for the rule of law? And if you follow that true north, then the people of your state will respect you for it.
It's a great answer.
But this is also a teaching moment for our entire nation, because so much of our experience under President Trump reflects upon the founders of this great nation, and that all three levels of government are co-equal. And so it's really critically important that individuals understand that each branch of government is a check on the other. And so if we educate the general public about the role of government and about the co-equal branches of government, and recognize that this president has politicized just about every facet of each agency, then it's our duty and our responsibility to stand up, particularly when a president is out of bounds and he engages in politics for no other purpose, for some nefarious purposes and purposes that are clearly illegal.
Let me use that as the perfect occasion to go to Attorney General Becerra and want to talk about a case that's before the Supreme Court. It's going to be argued soon after Election Day. The case is called California versus Texas. I just find the title of the case so evocative of where our country is at this point in time. And it involves an enormously important federal law, the Patient Protection and Affordable Care Act. It's estimated between 20 and 25 million people are getting health insurance because of it. It's coming to the court in the midst of a pandemic. Do you want to explain a little bit about what the issues are and the role that you're playing in the litigation?
Sure, Dean. And I think this is emblematic of what we've had to experience under the Trump administration. Texas sues the federal government saying the Affordable Care Act is unconstitutional, even though the act was before the Supreme Court, some 3 years before that, and was upheld by the same court as being constitutional. Texas and a number of conservative states sue. Donald Trump and his Department of Justice, as you would expect, are the folks who defend federal law, the Affordable Care Act. Surprise, surprise, a number of us didn't believe that Donald Trump and his Department of Justice would try to do a really good job of defending the Affordable Care Act. So we sought to intervene in the case, and we were granted intervention. And lo and behold, within a matter of months, I believe, of being granted that intervention, the Trump administration essentially backed out of defending the Affordable Care Act, a federal law, and left it to the states. And it's a large coalition of some 23 AGs that are now defending the Affordable Care Act for every American throughout the country. And it's very simple. The argument that Texas makes is because in 2017, Congress passed a tax bill. It was a tax cut bill, if you'll recall, in December of 2017, where one of the things they did was they essentially zeroed out the amount that you would have to pay in personal responsibility fees if you didn't purchase a healthcare policy in some fashion, either through the marketplace exchanges that were created by the ACA, or you got it through Medicaid. If you didn't have health insurance, you would have to start paying a fee, a responsibility fee. It's very similar to auto insurance, right? Well, the amount of that fee got zeroed out by Congress in that 2017 tax cut bill. And Texas and its fellow states argued that, hey, because that's been zeroed out, there is no longer a basis for the entire Affordable Care Act, including the prohibitions against discrimination based on pre-existing conditions, including the new services that seniors get under Medicare for cheaper prescription drugs because of the reduction of the donut hole coverage. 26-year-olds and under being able to stay on their parents' health insurance policy. All those things were supposed to die because Congress in that tax bill said, we're zeroing out the amount that you have to pay as a personal responsibility fee, which the court called the tax. So the tax is zeroed out, and because of that, the entire Affordable Care Act should fail. We're in court, and all three of us are a part of this, and we'll be arguing the case. California will be arguing the case on November the 10th, 1 week after the election, to defend the Affordable Care Act. And certainly we believe the entire act is constitutional. But even if that one provision of taking out the individual mandate, as it's called, to pay a fee or a fine is found unconstitutional, then it should be severed from the rest of the Affordable Care Act, and all those other crucial provisions for Americans should remain. There are 133 million people in America who have a pre-existing condition. None of them, and even if you don't have a pre-existing condition, none of us wants to go back to the days when an insurance company could say, you're a woman, you can get pregnant. That's a pre-existing condition. We can now deny you health insurance coverage. So we're in court November 10th. And I think everything we said about the analysis of the way the Supreme Court operates and has operated in these other cases will apply in this case as well.
It's a strange case because you're right. In 2012, the Supreme Court 5-4 upheld the individual mandate in the Affordable Care Act. And yet we know from what went on before that litigation and what went on in this litigation is how ideologically divided perceptions of the Affordable Care Act are. I have to admit, when I first heard of this issue, it seemed to me almost a frivolous argument being made against the Affordable Care Act, because severability, which you refer to, comes up when a court declares part of a law unconstitutional, and you then ask, would Congress have adopted the rest of the law? This is Congress not repealing, but changing one part of the law. But it's clear what Congress wanted, because the very same month, Congress voted not to repeal the Affordable Care Act. So it's about congressional intent, isn't it clear? Attorney General Weiser, Attorney General James, you're both involved in this. Do you have thoughts about this case and the coming argument in the court?
Listen, the real impact of this case is impossible to overstate, particularly in light of COVID-19. Tens of thousands of people obviously will be impacted by this decision. And this administration has tried to dismantle, they've tried to chip away at the many healthcare protections in the ACA. And what is so ironic about the whole situation is that so many Republicans are running ads saying that they support pre-existing conditions and that they support the ACA, when in fact we know that this administration has basically this disregard for the health and the well-being of countless Americans. And it's so unfortunate. I was talking to one of the candidates who's running for Attorney General in West Virginia, and he told me about all of the coal miners and their families who rely upon ACA. And it's so really critically important that we defend the ACA, which is why it's an honor and a privilege to be with my colleagues on this panel this afternoon.
Attorney General Weiser, your thoughts about this case?
Yeah, let me add one point which General Becerra, in eloquently talking about this case, did mention. The Medicaid expansion is on the line here also. 400,000 Coloradans have health care because of that expansion. Rural hospitals are in danger of going under without it. That's a practical consequence. But back to our earlier conversation, it's also the rule of law. We have the rule of law as Americans because we believe in the rule of law. If people lose trust in our judicial system to act independently, as opposed to based on naked political or ideological actions, that threatens the rule of law. Here, we just saw the Supreme Court decide a case involving robocalls where they used the severability doctrine. I believe that was a 9-0 decision. This decision should be 9-0. And it will be a huge accomplishment both for General Becerra and his team, and also for Chief Justice Roberts to deliver a 9-0 victory, which is victory for Americans who depend on the Affordable Care Act and who basically are wondering whether the rule of law is real. Now, what someone might say is, I still think this law is unconstitutional for the reasons in the earlier case, but then you're quarreling with the earlier precedent. That's not what this case is about. This case is about whether lowering that fee all of a sudden can then be used in this sort of quadruple bank shot sort of way to invalidate the whole law in the face of congressional intent to the contrary.
As to 9-0, if my grandmother were still alive, to say from your lips to God's ears, but 5-4 would be really nice too.
As long as we win.
It's to, let me shift a little bit in our remaining time. Another key role that state attorney generals play is in the amicus briefs that are filed in the Supreme Court. And often you join together in amicus briefs. A year ago, I had a case in the Supreme Court where I think almost every state attorney general filed a brief against my position. I forgive you, we can talk about that. When do you decide to file amicus briefs? And do you think the amicus briefs coming from the state attorney generals make a difference?
I do. You know, similar to what Justice Roberts attempts to do in the Supreme Court, it's all about teamwork. And clearly, it's here in the Democratic Attorney Generals, we're a team. We talk regularly. We support one another as much as we possibly can. And I believe that amicus, the amici, they obviously go a long way in defending democracy and standing up for the rule of law.
Other thoughts on amicus briefs and the difference they make?
Go ahead, Phil.
Becerra?
Phil, go ahead. I'll...
They can offer valuable context. Part of what makes the state attorney general job so important and special is that we're close to the ground and the people who we serve and represent. And so, for example, I want to commend General James. Her leadership on reproductive rights is second to nobody. And we've been honored to join with her as she's led on that issue. The consequences of overturning or even dramatically curtailing Roe versus Wade, like the Louisiana case you mentioned, is dire. And we have a generation or two generations of people who the term back alley abortions doesn't resonate because they've not lived through it or seen it. But we are threatening to go back to that era, to put people, particularly poor people and people of color, in a position that is unconscionable, and people should never be put into this situation. In some of these states recently, even if you are raped or a victim of incest, you're being told you can't get an abortion to protect yourself and your mental health. That's a scary thought. And I think the, again, real life, almost Brandeisian brief perspective that we can bring is value added for sure.
Attorney General Becerra?
I'll just add that the state AG, since we represent the people of our state, not individuals per se, sometimes it's tough for us to have the ticket to get through the door to file a case. And so we may not have the standing that others who are directly harmed would have. And so these briefs, Friends of the Court briefs, are crucial. And that's why I think so often we are asked as state AGs to join in some of these briefs. So I think that's it's been a phenomenal tool that we've been able to use. But I would like to comment on just the teamwork. And I think AG James mentioned this. I think it's one of the greatest aspects of being an AG, and one of the things that I've enjoyed most is just the camaraderie that's developed among AGs in working together. There are very few cases that any of us file where we don't have just this great team behind us. The Affordable Care Act, some 23 AGs. Most of these cases, the census cases, the DACA case, always have this, it's not a pile-on, but I think everybody understands the importance. And I think it's been great to know that when you can't take on the load by yourself because you got another important case going on, there will be someone in the AG world who will pick up and take responsibility for that case. And that makes it possible for us to have this really massive impact on these laws, because we can hit from so many directions and be ready to launch.
And let me just also say that, sometimes we also work together in a bipartisan manner. I mean, on opioids, we're all together, and in a number of other cases, we're all together. I've only been elected as an attorney general for a year and a half now, but I do know from time to time, we all work together as one. But for the most part, most of my work is focused on joining with Democratic attorney generals.
We have less than 5 minutes left. The hour went by really fast. I think I'd ask each of you to take just a minute in your thoughts about the current Supreme Court and how you as a state attorney general want to approach it. I'll go reverse alphabetical order, starting with Dean Weiser. Attorney General Weiser.
Weiser works too. I tell people, call me Dean Weiser, call me Phil, whatever. It's all good. The Supreme Court is an institution that at its best is about principle. And the case that I argued was a blessing, and you picked this up, that it was argued away from the presidential election. Had the case been argued where people knew what was at stake, then it would risk becoming more politicized. But as a matter of principle and about constitutional design and about our democracy, I think we saw the Supreme Court at its best. I got hard questions from Justices Kagan and Breyer, as well as Justice Gorsuch, and they weren't, let's say, easily pigeonholed based on ideology. It was about a search for truth. And when I clerked for Justice Ruth Bader Ginsburg, that's the Supreme Court I saw, operating together as a team and with respectful dialogue that made decisions better. Justice Scalia and Justice Ginsburg didn't always agree on everything, but they had respect for each other. And that is what we need in this country right now. We need institutions that operate based on respect, based on a search for truth, based on rigorous analysis with the people in mind. And Roberts, as a steward of the Supreme Court, is, I believe, pragmatic, is an institutionalist, and the court is holding on to that tradition. I think it's crucial that that tradition be continued. It's risky if you get people who are too ideologically committed on the court, because it can bring you away from that tradition. So that's what I see in the court, and I do think the court has showed up in a number of the cases we talked about as a defender of the American people and the rule of law.
Attorney General James, for a moment.
So Roberts is not a purist, but he's a stickler for rules. And he has expressed a concern for precedent and a concern with regards to reliance interest. And so he's expressed reliance in regards to overturning Roe versus Wade in the June medical service, where in the previous case, a similar case in Texas, he dissented. Again, he expressed concerns with regards to the hardship for DACA recipients, as well as the census overall. So just like all of us, again, engaging in teamwork, he's trying to engage in teamwork and trying to build a consensus on the court. And it harkens back again to the framers of our Constitution who established co-equal branches of government. And I am so glad that we have an opportunity to seek justice in the courts, justice for the constituents that we represent, and justice for the rule of law at a time of chaos and complete confusion.
Attorney General Becerra, the last word.
Listen, I I don't believe that these last 3+ years are anything like normal. And I think most of us in this country would like to get back to a sense of normality. And for AGs, that typically means we have to wait till something's upon us so we can actually then take action. And that big stick that we use, we walk softly and then we carry that big stick, and that big stick is the U.S. Constitution. And we intend to use it because I believe the court agrees with us that this is 2020, not 1920, and that it's up to us to make sure that we return to a normal 2020. And so I would simply say that as we move forward, as much as the court might be divided, I think each and every one of us recognizes that we should never do mild when we go into court. If we're going to sue, you do not do mild. You're not going to tiptoe to success. And so if you believe you have to use the court, use it right, because they'll understand that this is 2020, not 1920.
With that, I want to thank each of the attorney generals. I want to thank you for letting me be part of this wonderful conversation. And most of all, I want to thank you for all you do in your work. And so with that, I'll say to everybody, please take care and be well.
Thank you, Dean.
Thank you.
Thanks, Dan.